Just some housekeeping, but I'll do our little spiel just to be on the safe side. Good evening, Luke Mortensen, and I'm with our staff liaison, Catherine Week, tonight. Please silence your cell phones to minimize distractions during the meeting. Like I said, we don't have any variance items, but if and when the chair calls for public comment, please approach podium to indicate you wish to speak. Virtual participants should use the raise hand function to indicate they wish to speak during public comment. Once your name is called, please unmute and turn your camera on to provide your comments. Please state your name and zip code before speaking. The city reserves the right to turn off videos or mute participants. All comments will be, the primary format for accessing and participating in this meeting is in person at City Hall. Virtual access to view or participate in the meeting cannot be guaranteed, and the chat function will not be monitored. With that, we'll throw it to Catherine to check for quorum.
Okay, so briefly, right before quorum, I just want to make everyone aware that we do have a new commissioner or board member with us this evening. Josh Rosa is our newest Board of Zoning Appeals member. Welcome, Josh.
Hello, glad to be here. I'm virtually tonight and have my son, we're getting ready for bedtime, so I'll be following along, but if there's background noise, there's that.
Okay, no problem. So I'm going to go ahead and call roll. Palos?
Here.
Peterson?
Here.
Rankin?
Here.
Rosa?
Here.
Okay. Shanuda?
Here.
Sinkler?
Here.
And Watkins.
Yep.
All right, we do have quorum. So also tonight, I'm going to start it off with Adam, who's our current chair, and so he can get the ball rolling. But item number C tonight, just to make you all aware, so be thinking about it, is nominations for chair, vice chair, and we also have to vote on secretary. So just keep that in mind while we go through the first part, because we'll be doing that shortly. Okay, go ahead, Adam.
Thank you. Let's go through communication section. Is there any communication to come before the board?
We have no communications this evening.
All right. Any ex parte communication or, yeah, I guess there's no really specific agenda items.
Yeah.
So.
Yeah, there's no items, so there should be no ex parte communications.
And so since there are no items, I guess there's not going to be any items that will be deferred.
Correct.
All right. Let's move to the next section where we will get a new chair and vice chair. Does anybody have any nominations? Anybody have any strong opinions?
I would nominate Patrick for the chair.
Thanks, Peter. Anybody care to be chair or vice chair? Anybody have aspirations for it?
I don't at this time.
Yeah.
I'll second that if you need a second.
What about vice chair? Anybody interested in that position?
So just to keep in mind, vice chair, the role is basically if for some reason the chair is unable to attend, you would just fill in to run the meeting. So typically that's what happens.
And then some people might presume that you want to be chair after you're vice chair.
Well, that's always possible.
Yeah. It seems like we ought to have somebody nominated for that position. Anybody opposed to being vice chair?
I am.
I can do it if we're looking.
I
for
nominate
people.
Peterson for it,
There you go.
for vice chair.
Okay, and I'm fine being chair. I'd be happy to.
Yeah, yeah.
So the current chair, we would just need a motion and then a second for those nominations. And we can do the secretary at the same time if you choose to, or we can do that after.
Yeah, can we go ahead and add having you to remain, Catherine to remain as secretary?
Okay, so we would just need a motion to incorporate all three roles.
I would move that we approve Patrick for chair, Haley for vice chair, and Catherine as secretary.
I second that.
Okay, all in favor?
Aye.
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 Show of hands. I didn't see Josh's hand, so Josh, can you?
Oh, sorry, I'm
Okay,
still
perfect.
getting used to
Okay,
it.
looks like it's unanimous, thank you.
Patrick, it comes with a raise.
So Patrick, as the new chair, do you want to continue down the agenda for?
Sure, yeah,
item D?
let's
Okay.
get through it. So we've got to consider approval of the minutes from September 4th. Any discussion or commentary on the minutes from September 4th meeting?
I move approval of the minutes.
Okay, we've got a motion from Dean,
Oh, I will second that motion.
second from Haley. Show of hands if you support approval of the minutes from the September meeting.
It looks like.
Josh, are you in there too?
6. I don't know if Josh is still with us.
He did, well.
Oh, he did.
Raise his hand.
Okay, so it
Okay.
looks like 7.
All right.
Yep, still here.
Okay,
All right, so we have approval of the minutes, and we've got a Board of Appeals orientation training.
yes. So Catherine Week, staff liaison. We go through this every October, so this is a refresher for most of you. I did go through and update code sections. Initially, I saw in the packet today, it got uploaded without the updates to the new code sections, but I've since corrected those. So the new code sections are in. Josh and maybe Haley, I don't know if you have a copy of this. If you need a copy for some reason, let me know or email me, and I can get you a hard copy. Otherwise, if you want to refer to it online, you can do that as well. So just let me know.
Sounds good.
Okay. So getting started on this is, of course, our annual training for the Board of Zoning Appeals. The reason why we do this is because the role of the Board of Zoning Appeals is a little different than our other volunteer boards and our commissions that actually make some legislative decisions, which we don't do. So anyway, let's get this going here. We are a dual role board, so we actually have 2 roles, and they are separate, so we log in and log out, or basically roll call in and roll call out for each role that we are undertaking. One is the Board of Zoning Appeals, which is the hardship variances. That typically is what you see most of the time. We also, this body acts as the Sign Code Board of Appeals.
Hey, Catherine, I'm sorry.
Yeah.
I just need to get this figured out.
Okay, no worries. We're still on the first slide. So we currently act also as the Sign Code Board of Appeals, and as I mentioned, we will gavel in and out of each one of those roles as we see those items come before us.
Okay, we're good.
You good?
Yep.
Okay. So our role is a quasi-judicial role. It is not judicial, so I want to make that clear. We are not a judicial body. To be a judicial body, you actually have to have a judge. We are not a judicial body. We are quasi-judicial, meaning that we weigh facts before you, and then you make a determination based on those facts. And we will do that, or the board will do that on hardship variances, administrative appeals, floodplain, can't even say that, floodplain variances, and sign code variances. And basically, quasi-judicial is it's partly a judicial character in the fact that you are holding a hearing, listening to the facts, and then you weigh in on the criteria points and the code as it is adopted by the city. So our role, and this is one point that we really want to hone in on, the role of the Board of Zoning Appeals. The role of the board is not to offer flexibility in the code. The role of the board is a state statute mandate for any municipality that has enacted a zoning code. So if you have a zoning code, you have to have a body that can weigh in whether or not your rights have been deprived as a property owner based on meeting those code requirements. You have to have a safety mechanism, and that is what our role, or this board's role is. They're designed to alleviate a loss of rights, and that loss of rights is not something that is created by the property owner or business owner. That is basically a loss of rights that has been created by the adoption of the code or change in zoning. So we want to really keep that in mind and try to remember that, a lot of things that may come before you do seem reasonable, and you just have to really fall back on this role as a safety mechanism, and you are equalizing the rights of someone that has lost a portion of or their right to utilize their property in the manner that has been intended. So a couple of things about the differences between boards. It does get a little blurry sometimes, so I always want to put this slide in just to reiterate. So the City Commission, they are a legislative authority. They're the ones that actually create the code and adopt code. And they may create it based on proposals made by other commissions or recommending bodies, i.e. a planning commission. So the planning commission will propose the code, and they adjust long-range plans, and they guide future development. And in some cases, they also have a role as a quasi-judicial board in that they offer subdivision variances. That is different than hardship variances. These are related to plan, like platting, subdivision, subdividing. So they will sometimes have that role as well. It's also quasi-judicial, but typically they are a recommending body. The Board of Zoning Appeals and Sign Code Board, they apply the current code. So we really have to reiterate for board members that, you may have opinions about the code. They may or may not be how it is outlined in the current code as it is adopted, but your role is really to just apply the code as it's adopted. It is totally appropriate if we are seeing a number of the same type of zoning variances come before you, where you would direct staff to maybe inform the planning director that, hey, we are seeing a lot of these variances. Is something going on that needs to be changed in the code? And then it would go through the process of, the planning director making the planning commission aware, or the city commission, and going through that process of getting that code section changed to accommodate that. One of the goals of the new code is to offer a little bit more flexibility in meeting the requirements without having to go through variances. There are some things in the new code, such as administrative adjustments, that can alleviate some of those common variances that we've seen in the past. For instance, like setbacks. You can get administrative adjustments now for good cause, where you may not have to come before the board because you're not really losing a right. You shouldn't have to go to the Board of Zoning Appeals to get this. You should have some leeway and still meet the requirements of the code, but you don't have to go through the hardship variance process to get there. So hopefully our new code, and we haven't really fleshed it out enough.
Excuse me, Catherine, it's Dean. Could you go back over that again? What no longer needs to come before us?
Well, so there are instances in the new code that provide some opportunities for administrative adjustments.
Okay.
So those dimensional standards, which are what you all see before you, dimensional standard adjustments or dimensional variances, those things now have a mechanism in the code where it may not need to go to the level of asking for a variance, because there's an opportunity for some flexibility in an administrative adjustment. Some of those adjustments are up to 20%. For instance, if you have a 5-foot setback, you could potentially, in a case of hardship, ask for and get an administrative adjustment, so you could go down to 3 feet if it warranted it. And so that's an administrative decision by the planning director. And so that may alleviate some of the things that we were commonly seeing. We don't really know yet because we've only had the code for a few months, but we'll see how that plays out. That was kind of the intent.
So that's up to the director to decide that?
Administrative waivers are a director of planning determination, yes.
And I assume there's some kind of appeal process internally for that, I guess?
That would be this board. So all administrative appeals would come before this board. We'll talk about those in a second, yes. So there's definitely an appeal process, yes.
We can have Danny send out the section that Catherine's talking about.
Would you?
Tomorrow.
Yeah.
And it's pretty digestible. It's just a couple pages long.
Yeah.
Okay.
Yeah, that would be
Yeah,
great.
I'd be interested in that.
So that is one of the new features of the new code to help provide some flexibility and understanding for what you have to do to meet the requirements. So in that reference, or in that frame of thought, what is a hardship variance, which is what you are hearing. And again, that is typically when it is literally impossible to meet the dimensional requirements of the zoning designation for a use that is permitted in that designation. So that is what the hardship is geared for. It's basically you are not able to utilize your property in a manner intended similar to other properties in the same zoning district as a permitted use. You should be able to do that. And we're going to talk about this a little bit more with the definition of unnecessary hardship in a second. There are two types of variances. We will only see area and dimensional standard variances. Kansas statute prohibits use variances. There are some jurisdictions that use those. We are not allowed to do that in the state of Kansas. So you only see dimensional standard variances, not use variances. A use variance would be something like allowing, I don't know, a gas station in a residential district where it's typically not permitted. That would be an over-exaggeration of a use variance, but that would be something similar to that. There are additional limitations placed on what the role of the board is. Plan developments do not go through the same variance process that traditional or straight zoning designation properties can go through. Plan developments have to, if they're going to do a modification or somebody is asking for something to vary from what the plan development outlined, there's a process for that separate from a variance. They basically have to revise the development plan to accommodate any modifications. And there is a process in the code outlined for that. And then also, anything that's prohibited in the city of Lawrence or prohibited specifically in the code, you are not permitted to give variances that are prohibited or prohibitions. Just because if it's deemed to be not permitted or prohibited or illegal in the city, the board is not authorized to counter that. So applications are processed, just like all of our other applications, through the Land Development Code in Article 16. Variance applications you cannot apply for a variance to a process. So process applications are not something that you could ask for a variance from. We've had applicants ask for that, but that is not something that you all have the authority to do. And then you will see administrative appeals also. I kind of jumped ahead there, but these sections outline where you will find those things. So variance application, the outline for the process for that is in 2016-04F, and then administrative appeals are in 2016-04A. So we're going to talk a little bit about unnecessary hardship, and we may have a change coming up to this. So unnecessary hardship is one of the criteria points for, as you know, reviewing a variance. There are 5. Basically, the gist of it is that you have to meet the specific definition and that you're unable to utilize the property for that conforming use in the zoning district with those dimensional standards that is outlined for that use in that district. And somehow it is depriving the owner of their right to utilize the property in that manner. We do have a text amendment before the Planning Commission. It has not yet gone to the City Commission, but it did go to the Planning Commission at the last meeting to modify the definition of unnecessary hardship. So currently, I'm going to bring up just the brief text for what that entails here. Where did I put it? So currently, in our current definition for unnecessary hardship, we reference use in the definition. And so I'm going to read it briefly because it's a substantial change. So in the 2006 code and prior, the definition is that the conditions resulting from application of these regulations when viewing the property and its environment that is so unreasonable as to become an arbitrary and capricious interference with the basic right of private property ownership, or convincing proof exists that it's impossible to use the property for a conforming use. That's a key sentence because that is going to change. Or sufficient factors exist to constitute a hardship that would in effect deprive the owner of their property without compensation. and mere financial loss or loss of a potential financial advantage does not constitute a necessary hardship. So the proposed text amendment is going to remove that reference to other uses or conforming use. Because the concept is that if that use is permitted in that district, you should be able to do that use on that property. What is hindering maybe or making the hardship or unnecessary hardship is that the dimensional standards do not fit, say, the lot for it to be utilized in the manner that is intended for that use in that zoning district. And so a new language format that the Planning Commission is recommending approval for the City Commission to consider is that an unnecessary hardship exists when a property owner can demonstrate that the property owner is unable to develop or use the property in a way that is proposed that is reasonably permitted by Chapter 20 of the City Code as amended. The claimed hardship must involve more than mere inconvenience, a preference for a more lenient standard, or financial loss or loss of a financial advantage. And so that's really getting to the point of, if this use is permitted in the district and, you know, this is your district, you should be able to somehow utilize that use in that district. And so if the dimensional standards are creating an unnecessary hardship and you are not able to do that, it might rise to the level of qualifying for a variance. And I think that's the clarifying factor, that we shouldn't be referencing other uses that might be permitted in that district. If it's a use permitted, you should be able to somehow utilize that use in that district. And if you have questions, we can chat about that. But that is the basic change. Hopefully I explained that succinctly enough, but.
Catherine, this is Dean again.
Yeah.
I feel like Patrick and I ought to comment on this because we were both involved in getting that change made. I just wanted the rest of everybody to know that.
That's, I mean, we can talk about that?
Well, no, I think the decision that was made by the Planning Commission, I don't have any comment relative to that, but I just wanted everybody to know that we spoke to the Planning Commission about that change.
And I should chime in, I mean, this stems from the district court's ruling on
Yes.
the recent review of the variance for Charlie's East Side. District court noted that the standard that we apply, the former, or the definition that we're currently applying, is higher than other standard. It's a different standard than other jurisdictions apply, and it's higher than what state law supports. And so I fed that, or I provided that to the planning staff and crafted an application to allow our language to meet the state law standards. And so it went before the Planning Commission this last month. And then it's going to go before the City Commission at some point.
Yes.
But it stems from the district court's guidance on this. And I've got some other commentary on this. I don't want to derail us, though.
Okay, yeah, I mean, we can chat about it in a few minutes. But yeah, that is a good point to note, that this, it does stem from Kansas case law. I mean, it wasn't just a random, request. So, and the city attorney has reviewed it as well. So just FYI. Okay, so moving on with these are our 5 criteria points that you look at with every unnecessary hardship or hardship request variance. The 5 are uniqueness, no adverse effects to neighboring properties, unnecessary hardship by definition, and then health, safety, and welfare, and then the spirit and intent of the code. And we can briefly look at these individually. We don't necessarily need to go in through all of them, but I will reiterate that you do have to look at all of them when you're reviewing every variance, and they have to meet all 5 criteria. They can't just meet a majority of them or some of them. This being a quasi-judicial board, the threshold that Kansas state statute spells out is that they have to meet all 5. So when you're looking at a variance, keep that in mind. So you get a staff report. I kind of skipped ahead, Luke, to the staff report section. So you get a staff report or a staff recommendation with every variance that comes before you. Staff has to do the exact same thing that you all do. We have to analyze the request on those 5 criteria points We try to gather all of the relevant information that we can find about the context, the site, when it was platted, what was it zoned, and we try to provide all of those things for you in the staff report. We actually are required to provide you a staff report so that you have all of that information before you, and then you also have whatever is submitted by the applicant. This board is a little different in that we don't have like presentations or, please, they're allowed to speak, but the facts that come before you are what is submitted in the application, and then staff's recommendation as required by state statute or by code. So, and again, we try to provide you as much information as we can. You may or may not agree with our analysis, but we are trying to do the same analysis that you all would do when you're looking at those. So again, we also hear administrative appeals. So this board is the review body for an administrative appeal. And then an administrative appeal would be any alleged error in an order or a requirement or a decision or a determination that's been made, such as by the planning director or an administrative, requirement, a code enforcement requirement or something to cease and desist use of a property if it's deemed one use, for instance, and they disagree that that is not that use. We had one like this probably 4 years ago. Then that could be appealed, and that would come before you. And again, it must meet the application requirements for an administrative appeal. There are some requirements spelled out in that section. You have to have standing to file an administrative appeal. And then the board cannot overturn a determination or order a decision unless there is substantial factual evidence that an error was made. So the burden of proof is on the appellant. Again, staff will provide you with a brief report in the cases of administrative appeals. And again, we will try to give you just timeline. Here's the decision that went out. Here's the appeal that came in. Here's how it got to that point, so that you have all of the facts, and we will try to cite all of the code sections that got the director or whoever is being appealed their decision to the point of whatever decision it was that they made.
Catherine, maybe I'm getting ahead of you, but if the applicant isn't satisfied with the results of the board meeting, do they have a avenue of appeal, or?
Yes, they do. So because we are a quasi-judicial board, this goes straight to district court. So if they have a disagreement with the Board of Zoning Appeals and wish to appeal their determination, it goes to district court. It does not go to planning commission. That's a little different. For instance, like if someone were to appeal a historic resource commission determination, that goes on to city commission, and then it would go to district court if that, or any other jurisdictional court. But here at the BZA, anything that they want to appeal that you all have decided on, they have to take to district court. And it is up to them to do that. We get notified, the city attorney's office gets notified if someone does file an appeal. So, again, there's some limitations for what can be appealed. I think this is where I jumped ahead before. Staff reports are not administrative determinations, so a staff report is basically us doing a professional analysis and giving you a recommendation. It is not appealable. Planning Commission is not an administrative official, so they cannot appeal Planning Commission decisions. That would not come before you. That goes to the City Commission if Planning Commission decision has been appealed. And then any review procedures, as I mentioned in Article 7, so like what is the process for an application, for any type of application, they can't appeal the review procedures in 16. And again, cannot overturn an appeal unless there is, or cannot overturn a decision unless there is substantial factual evidence. And so as a body that has a quasi-judicial role, you have some options for your decisions. They're limited, but you have options. One is you can approve the variance. 2 is you can approve it with conditions. Or 3, you can deny the variance. There is one other where if you do not have enough information to make a determination at all, you can remand the item back to staff to gather additional evidence, information, and bring it before you. Those don't happen very often, and oftentimes board members have questions about what does that mean to approve it with conditions. It's kind of a little bit of a narrow option. You can approve it. For instance, sometimes we get multiple application types in for one project. They may have to plat, site plan. You could say approve a variance with the condition that a site plan is subsequently approved. So they may be in the process of splitting their property. You think it's a good idea that they meet the criteria and the variance for lot width, or not lot width, but setback and orientation of the building is not going to work unless they have a variance, but they wouldn't be able to do it anyway unless the site plan is approved, so you condition the approval with the approval of the site plan. That's one option. Other options, kind of outlined by the city attorney, would be like, if for some reason there's a safety concern, you might approve the condition with, trying to think of an example, for maybe like a sight line, like they're wanting to encroach in a sight line triangle as part of the setback, but if they encroach, that impedes the sight line, so that creates another hardship for others. You might say limit the height of an item that's going to encroach based on a safety concern. That might be a condition that you would do. So those are kind of broad spectrum examples. On the appeal, you also have, again, 3 options. One is to reverse that determination. If you find that there is an error that's obviously been made, you can reverse the determination, and in that case, you are acting as that administrative authority where you're saying, nope, this was wrong, they made an error, here's the determination. So you are now acting as that administrative authority. You can affirm the determination. You say, no, we don't find an error. We stand by that determination. Or you can modify the determination. You could find that an error was made in a portion of the determination, and you can modify it in some way to correct that error. So a little bit more about decisions. I only put this in there because as humans, we feel for the people that are coming before. Sometimes they have not been before the board or any board, and they have passion for their property, and it may be upsetting. But if you have to remember that you are not there, to make favorable and unfavorable decisions, you are only there to adjudicate the code. You're only there. Have to have a little bit of level of detachment and just say, I can only look at these 5 criteria and what the code says. And that if it doesn't meet the criteria, then the denial is the correct action. So after decisions are made, again, we talk a little bit about what their path is if they don't agree, but just so you all know, variances expire in 24 months if a building permit has not been obtained. So that variance, one thing I didn't mention is those go with the land. So once you grant a variance on a piece of property, it goes with that land until such time, say, that property changes form. For instance, if it becomes sucked up into another land combination or something and is no longer in that form, then the variance may be moot. But as that land exists, and if you grant a variance while it's in that form, it carries on whether or not the structure comes down or stays there, a new development comes, that variance still sits on the land. So they do expire in 24 months if a building permit has not been obtained once the variance has been granted. So they do have a timeline. If they don't utilize the variance, it does expire. And then any person aggrieved of any decision you all make does have 30 days to appeal that decision to district court. Let's see. So moving on to the Sign Code Board of Appeal role. Occasionally, individuals will file a variance request application for signs. They also have to show that there's some hardship in meeting the sign code. These criteria points are not quite as strict as the ones for a hardship variance, but they are still 3 criteria points that you have to, they have to meet all 3 before you can grant that variance. So those 3 criteria points for sign code review, again, are uniqueness. And again, it should be something that's unique about the site, not something that the property owner has created or a preference the property owner or business person has. It has to be something inherent about the site that makes it difficult to provide a conforming sign. And those instances do come up. One thing I should stress is using another code requirement to justify a unique element of a site is not good practice. So for instance, if, I'm going to use this as an extreme example, but if a property owner were to say, I can't put a sign on this property unless it's, 5 times bigger than I'm allowed to do because there are street trees on the right-of-way. That may be true, there may be trees, but every property in the city of Lawrence, whether it's commercial or residential, is required to have street trees. So that is not something that is unique to the property or development for a sign. And again, I'm using that as an extreme example, but just keep in mind that it should be something inherent about the site. Now, if the site is 20 feet up and, traffic is 20 feet below it or something, we do have some hills around here. That might be a unique situation where nobody can see the sign. Somehow they may have to either encroach upon the setback or make it a little bigger so that it can be viewed. So that might in fact be a good example of where the uniqueness comes into play. Again, whether it's affecting public welfare, and that ties back to that other criteria point and the unique hardships about, affecting others or neighboring properties. And then again, unnecessary hardship. And I might note that right now, we are not changing the definition here for unnecessary hardship, even if the text amendment is approved by the City Commission. But at some point in the future, I think, because there are other modifications that may be happening to the sign code, that would be one where we would probably want to unify the language so that it's in all locations. More about just how we in our agenda, you'll notice that any deferrals or withdrawals of any item, they need to happen prior to hearing. We usually do those at the very beginning of the meeting. You'll see them at the beginning of the agenda because we cannot start a hearing on an item and then it gets deferred. Once the hearing is opened, you have to make a decision, basically. So if there's going to be a deferral or withdrawal, they need to do it prior to the meeting. And then the staff liaison will notify the board in that opening portion of the meeting if we have any of those items. Also, abstaining and recusing must also occur prior to hearing the case. So if you are a member that for some reason needs to recuse or abstain from that item, you do need to identify that is the case at the beginning of the meeting, and then when that item comes up, you actually have to leave the room. So we have a chamber here. If you're in person, we will have you in the other room until that item's over. If we're on a virtual meeting, we will put you in the waiting room, and that is that is city policy, that if you're abstaining or recusing, you cannot be in the room. Motions for the board, they should be clear. And they should include the variance request as stated in the application of the staff report. The motion, and this is just to make it simpler so that you hit those 5 criteria points, because that is the most important thing. For instance, if for some reason your decisions are appealed and they do have to go to court, you have to show your reasoning for why you made those decisions. So it's helpful in the motion if you say the word because, and you just say because either it meets all of the criteria points, or because, staff's outline, we feel that is accurate in staff's description of those criteria points. Or if you, have 1 or 2 points that you feel it doesn't meet, and you have to deny, you say because it does not meet criteria 3 or criteria 1, or whatever that criteria may be. And that just makes it easier in the after, because we do have to do findings of fact occasionally if we have to go to court. So. Just a brief hit about attendance. Attendance is important for the Board of Zoning Appeals. We will adopt a calendar every November, so we give you those meeting dates ahead of time. You know, we ask you to block them off on your calendar and be there if you can, because attendance can affect quorum, and because the board only meets once a month, it can affect the applicant's timeline. They wouldn't be able, we would either have to call a special meeting, which also requires a 20-day notice, or it gets bumped to the next following meeting, which is 30 days out. So regardless, there's at least a 20-day delay. So it's important, if you can, to be at every meeting. If you can't, and there are instances where, you know, you can't be there, let us know ahead of time. So if you can let us know ahead of time, then we can plan ahead of time, for instance, if there's going to be a quorum issue, and we can potentially mitigate that loss of time for the applicant. Okay. And then this is just general conduct is expected from the City of Lawrence in general, in that we're expected to respect the public at all times. We allow all viewpoints. They may not agree with ours. We have to be impartial as Board of Zoning Appeals members or a body, and try not to prejudge the item. So really focus on those criteria points and the facts before you. And you know, you may have an idea about an item and come in, and after you look at everything, and you may decide, well, you know, my initial idea of that is not what I thought it was. So just try to be impartial and don't prejudge the item. Wait till you hear all the facts or read through all the facts before you know, kind of come to your determination. And then the city does encourage citizen engagement. Again, a lot of people come here and they've never been to a board, they've never had to, you know, ask for something from a body, and so they may be nervous, they may be emotional. You know, just try to be patient and welcoming atmosphere and encourage engagement. Sometimes it can be frustrating for all of us, and we just have to remember that it might be even more frustrating for them. So that is pretty much it. We do have updated email addresses. We have the .gov in our email addresses now, so this is updated. You can email myself with any questions that you have. If I cannot answer them for some reason, I have Randy on speed dial, our city attorney, so he can answer them if I can't. And if I'm for some reason not available, Luke can answer most of the questions as well. And then Denny is our administrative assistant assigned to BZA stuff, so if it's quorum or meeting related, you can also email her. So that's all I have.
Any comments or questions?
The new Commissioner Josh was raising his hand on Zoom.
Okay, thank you.
Yeah, I had a couple of questions. One of them was just if I could get like a link to that court decision that was discussed earlier in the meeting. And I'm not sure I recall what my second question was, so it must have been important.
Okay, I might mention too that all of that information was in the most recent Planning Commission meeting. I mean, we can definitely send you the link to that meeting, but it has like the requests.
No, I don't think that, just as long as it's there.
Okay, yeah, and the staff memo, there was an initial request, which I, in my error, forgot to link in the Planning Commission agenda. When the item first got initiated for City Commission, it was on consent. So there was a memo just saying it was initiating, but I can give you that link as well if you need that.
Okay, sounds good. I appreciate it.
The one comment that I had is just to distinguish, when applicants are looking at these 5 elements that you have to meet to be granted a variance, the third one is unnecessary hardship. And it's oftentimes believed to be the hardest one to meet. The previous definition, or the current definition, calls for 3 scenarios under which unnecessary hardship is met. When it's, and I'm just looking straight at the code language, when the condition is so unreasonable as to become an arbitrary and capricious interference with the basic right of private property ownership. That's one way unnecessary hardship is met. convincing proof exists that it's impossible to use the property for a conforming use, or sufficient factors exist to constitute a hardship that would deprive the owner of property without compensation. Those are the three scenarios under which unnecessary hardship is currently defined. And the new version is, I think, in many ways, substantially different. It doesn't include reference to any three of those. It still retains the minimum standard that this cannot be about mere financial loss or seeking merely seeking a more lenient standard. But the reference to those three different, rationales or definitions under which hardship is defined are removed. So from my perspective, it does change the dynamic on the hardest to receive element of a variance. But obviously, if you all have questions about this, I've looked at it in depth. I know Dean has too. We both have ideas about it, and Catherine's and Lucas are obviously available for anybody that wants to dig in and see a little bit more. And then at some point, it will be at the City Commission. I am essentially a public commenter on it, and you all would be too if you have input for their consideration. Is that all fair, Sarah, or Catherine?
Yeah, I would say that those three things that are not specifically spelled out, if the property had any of those things, I think it would still meet the definition of unnecessary hardship. It's just that it's not so narrowly defined. Yeah.
So in other words, if it rose to that standard, you would still have hardship.
Absolutely, yeah.
But I think the definition is a lower standard now.
Yes. I think it offers, so I mentioned, I'm not a lawyer, so my non-lawyer brain, and having been the staff liaison and going through many staff reports, it took a minute because it's a little different, but it actually makes sense because if you do have a property in the zoning district, you ought to be able to utilize that property for the use that is permitted in that district. And so the way the definition is crafted now is it really hones in on what's being proposed, not what else could be proposed here. It's really what is being proposed, and is that a permitted use? And does something unique about this site or whatever create an unnecessary hardship in meeting the dimensional standards for that? So I do think it is a little bit looser, but not unreasonable. Just from my own perspective.
And if this does move forward, we would incorporate that into the staff reports.
Correct.
And try to maybe beef it up a little bit in explanation language.
And we always include the definition of a unnecessary hardship in the staff reports because it is the only really thing that is specific, it's spelled out as a necessary hardship. So, one of the reasons why the definition in staff and city attorney's opinion is important is that because it calls it out in the statute, it should have a baseline for consistency just for you all, to make it easier for you all to form a level of consistency and for property owners to expect a level of consistency in how it's being interpreted. So, if that helps.
Any other comments or questions? Well, before we entertain a motion to adjourn, we should recognize Adam for his service. And, I've been on the BZA for, I don't know, not quite 2 years. And I think I've only seen one meeting where Adam wasn't there. And so he's been very diligent in attendance, and he served admirably. And, I guess we can recognize Adam. Adam, if you have anything to comment or say, now might be the time.
I'm glad you're taking over chair. How about that?
And we should know he's not leaving. He's just not being chair anymore.
Thanks, Adam. Appreciate it.
Yep, thank you.
All right, any motions or seconds to adjourn?
I'll move to adjourn.
I'll second.
All right, moved by Haley, second by Dean. All in favor?
All in favor?
show of hands.
Okay, motion carries.
Catherine, does it bother you if I just call those, or do you want me to wait, have you call the vote?
Say that again?
Do you want to call the vote on?